Stephen A. Williams, president and founder of the creditrepairshop.com. And in today's video, we're going to talk about a lawsuit that the CFPB had against several debt collectors. The direct defendant was Portfolio Recovery Associates, but in their agreement with their orders, which none of the debt collection companies stated that they were guilty of of any of the allegations, but the CFPB stated that they had beliefs that this was something that was prevalent in the debt collection industry, that something that was going on, and that they just didn't have all of the evidence to kind of uncover it, but put in 2 + 2 = 4 when you have certain consumers complaining about certain things when they deal with debt collectors. It kind of, they kind of came to the same realization that this stuff might be happening, but they were not able to get the full evidence on it. But they did put some guidance, and Portfolio did have an order placed against them, and they said that they were gonna that they did not agree with what was alleged, but that they were gonna follow the CFPB's orders moving forward, which would keep them out of trouble, but also it was going to be something that was going to encompass everybody, all of the debt collection companies. And this was something that also reached back to the original creditors, because the whole issue with this was that debt collectors were coming after people, and they didn't have all of the documentation to prove that they could collect on the debt. Now, I'm going to read a little bit from one of the attorney websites that did some reporting on this. I'm not going to show their information because I don't want to have any issues. Seems like if I put someone's website up, even if we give credit to them, YouTube can take those videos down. I think you can only show their stuff for a certain period of time. But let's just go over what the CFPB had claimed that debt collectors were doing. And it says that creditors allegedly failed to maintain accurate data about their own accounts or accounts they acquired from other entities. Now, when they say creditors, remember the Supreme Court had a ruling from Justice Gorsuch that stated that when a debt collection company purchases your old debt, that they actually become the original creditor if they are not in the business of going out there collecting for other people. So if a debt collector buys debt and they go out there and collect it for themselves, and they're not collecting debt for other companies where they're not hired to be a debt collector, they actually in a way assume the original creditor's position. I know it sounds strange, but this, you can look up Gorsuch versus Santander. I think it was, Henson. Santander versus Henson. Gorsuch is who wrote the decision on that. But look that up and you'll see that when a debt collection company buys your debt, they actually assume the original creditor position if they do not go out and collect debt for others. They buy the debt and they collect it for themselves. They assume that position. So even in this here, in the way that this was stated from the CFPB, it says creditors allegedly failed to maintain accurate data about their own accounts or the accounts they acquired from other entities, and failed to properly investigate consumers' disputes. This allegedly led to the sale of accounts with inaccurate balances or APR data. Validation. What do I say in my videos for fighting debt collection lawsuits? What do I tell you to do? Go and look at that video. I tell people that they have to prove everything about the claim. It's not just about the dollar amount. But let me continue. And the sale of accounts that were not owed because they were opened as a result of fraud, the account holder was deceased or in bankruptcy, or the account had been settled or paid in full. Debt buyers allegedly purchased accounts with inaccurate or unreliable balance information. They allegedly signed purchase and sale agreements that disclaimed the accuracy of the data sold and limited the availability of media they could obtain from the seller. When media was obtained, debt buyers allegedly did not review it to compare it with the electronic data they had been provided, nor did they require their law firms to do so before filing suit. Remember, I made, now, validation, let me just say it again. Validation alert. I made a video. It was actually a YouTube short, but I think I made a long form video about this. And I said that debt collection lawyers do not, I repeat, debt collection lawyers do not review the file when they send out those debt collection letters. And that if what you can do is you can request that a lawyer review that debt. Because once you do that, you will pin them down to all of this information having to be true that I'm explaining right here. And someone said on one of the shorts, one of the comments, and I understand why you said it, because it seems like it doesn't make sense. And that's because it's implied. It's implied that debt collection lawyers, debt collection companies, everything that they get has to be true because they bought it from the original creditor. So they got everything to prove. They got everything to prove it. That's what they want you to think. It states it right here. This is from the CFPB. It's not on their website, though. This is probably one of the law firms that was representing one of the debt collection companies. They put it on their site. So I told you, debt collection lawyers, they do not review any of the debt collection letters that are going out. And one of the ways that you can get them back on their heels is to request if the lawyer for their firm has reviewed all of the documents. So now, debt buyers allegedly continued to buy debt from sellers who had previously provided them with bad data. Reason why they kept doing it is because people did not know their rights on what they could challenge. Everybody thinks about challenging the amount on, do I owe them with the contract? Who are you, Mr. or Mrs. Debt Collection Company? That's where everybody's focus is. And then I try to get you to focus on, contract is one of the things. You want to see how they got that debt. But there's a whole string of other things that you can challenge: the balances, the payment history, the PIN codes, if you were charging with a PIN code, all of the signatures, PIN codes, APR, just stated it right there. The APR rate, interest rate charges, all of you open the door up on everything. They bought the debt, you open up the door to make them prove everything. And they just stated it here. I'll repeat it again. Debt buyers allegedly continued to buy from sellers who had previously provided them with bad data. So you're going to get stuff from an original creditor who gave you bad data. An original creditor gave you bad data, or had promised to supply the account documents but had been unable to do so. The reason why they're unable to do so is because some of the stuff that they have in there, they're not going to give over to a debt collection company. And this is the way the original creditors are looking at it. They're like, hey, you're buying this for pennies on the dollar. You're going to get what you get. You've been getting it from people. 95% of the people don't show up to court. You got all these default judgments. Let us get back to getting some new people to pay us, and you buy this debt and move on. Move on. That's what they're doing. And now when you have people like me that tell you how you can challenge them, now they go back to the original creditor. They're like, we need more stuff because we're losing these cases. This past Friday, we got 2 new cases, victories. One for $6,100. The other one was about $7,000 or $8,000. Victories. By simply giving people information to empower themselves to be able to beat debt collectors, not by running from the debt, by challenging all of the documents that they provided, not by getting into a back and forth and you're like, oh, I gotta come up with these documents to prove your case against me. No, I'm going to use your documents, your lack of documents that the CFPB said that you must have in hand to prove that debt when you're trying to go after somebody for it. When the consumer disputes debt outside of the 30-day validation period, this is continuing on, debt buyers allegedly made consumers prove they did not owe the debt. I'm going to repeat that again. When consumers disputed debts outside of the 30-day validation period, debt buyers allegedly made consumers prove they did not owe the debt and did not obtain or review account documentation to investigate the dispute, nor did debt buyers inform their attorneys if accounts had been disputed. Okay, now here is what the CFPB put into place. Consent order imposed following rules related to data integrity. Remember, all of this about data. Debt substantiation and dispute handling. Creditors agree to adopt procedures to ensure that they sell accurate documents and account information to debt buyers, and that sale contracts prohibit the buyer from collecting unless sufficient account level documentation has been provided. Future debt sales must include 12 to 18 months of account statements as well as a copy of the terms and conditions that apply to the account sold. Accounts with unresolved disputes should not be sold, and information about recent disputes and how those disputes were resolved must be provided to the buyer. Validation. Now, if you look at the summons, and I'm not going to spend a lot of time on this part because I want to keep focus right here. When you look at a court summons, they will say in there, and when I say they, debt buyers will put in their list of allegations, they will say that there were no disputes on file. They put that in there because this is what is required, but they don't put that in there because they know. They just put that in there because this is what they have to put in there. It is up to you. That's why I say when you respond, you're that 1, 2, 3, 4, 5. Those are allegations against you. And if they say you owe this amount and you don't have any affirmative defense against that allegation, you're already in trouble. They say that you didn't dispute any of the debts. How do they know you didn't dispute any of the debts? Disputing the debts is between you and the original creditor, and if they didn't pass those over, they need to go get them. They don't need you to tell them what those disputes were. They have to get it. But I've seen them try to pull that trick where they say, well, what are the disputes? Why are you saying what are the disputes when it is required, according to the CFPB, that you get all of those disputes when you buy the debt? Let's move forward. Debt buyers agreed to conduct a heightened review of the account documentation with respect of any accounts that have been disputed verbally or in writing, any accounts purchased as as part of a portfolio that contain unsupported or materially inaccurate information. Now, that's a key word. Understand when you review those sale documents that they provide with the original creditor, between the original creditor and the debt collector, that bill of sale, it will state on there that the information you're getting, you're getting what you're getting, and that it's accurate to the best of our knowledge. Well, what accounts are accurate to the best of your knowledge? If you're buying a big portfolio, $1 million, $2, $3, $5, $10 million portfolio for pennies on the dollar, and it states in there that we do not have any warranties or guarantees on the data. Well, on what part of the data? They are giving you an open door right there with their own documents. What part of your data are you not guaranteeing? I'll move on. Number 3, any accounts purchased pursuant to an agreement that lacks meaningful and effective representation regarding the accuracy and the validity of the accounts or the availability of media. The review must be of, and they call this OALD, original account level documentation. Remember that, original account level documentation. Remember that. That's going to be very, very important for you moving forward. If you have any debt collector that is suing you, and if you have any debt collector that is sending you debt collection letters, reflecting the charge-off or judgment balance. This is if they end up buying judgments from other people. And the OALD is defined: any documents that creditor or creditor agents as a servicer provided to the consumer about the debt, complete transactional history of the debt created by the creditor or that creditor's agent, such as a servicer, or a copy of a judgment awarded by a creditor or entered on or before the effective date. If the claimed amount the debt buyer seeks to collect is higher than the charge-off balance, the debt buyer must also review an explanation of how the amount was calculated and why it is authorized by the agreement or law. So they can't just buy the debt, say that you owe $15,000, and then they come at you minus the court costs, it's saying now it's $17,000. They have to give a reason behind that. You will see in the debt collection lawsuit summons that they will state that they did not add any interest or anything on the balance, that they have actually started saying that in there because they don't want to have any trouble with the case on saying, hey, you're already charging interest on this, and why? Like, what's the justification behind that? So you will see where and some of the times you don't even see this, but if let's just say that it was just a clean clean debt collection lawsuit where they had a statement that matched the amount that they had that they said that you might owe, that they allege that you owe. You rarely see that though. Before, what they used to only had to have was a couple of statements, and then they would have the amount. And they were basically using the statements to prove that you had the account, because the amount on the statement could be different than what they're claiming that you owe, because the amount they claim you owe came from another document that they got from the original creditor. Moving on, attorneys agreed not to threaten suit or initiate suit for a debt buyer without possession the original account level data reflecting the consumer's name, 4 digits of the account number at charge off, and I say you can still make them get the complete account number, but they're saying that the last 4 digits. The claimed amount, remember that keyword, I've always talked about that, excluding post charge off payments, and If suing under a breach of contract theory, the terms and conditions related to the account. In addition, attorneys must possess a certified or otherwise properly authenticated bill of sale or other documents evidencing transfer of the debt to each owner, which must include a specified reference to the debt being collected and any one of the following. One, a document signed by the consumer evidencing the opening of the account. Number two, original account level data reflecting a purchase, payment, and other actual use by the consumer. So this is some good information, and this is the information that you can utilize to stop debt collectors early. You can stop them early by doing your validation and requesting this type of information. Or if you're being sued by a debt collector, you can make sure that they're providing all of these documents. And this is what we've always done. All right, if you need help with your credit, please visit us at thecreditrepairshop.com. Watch video What Makes Us Different, so you can see my 8-point validation process, my 2-phase settlement process. If you need your credit reports and scores, go to the website your3scores.com to grab your TransUnion, Equifax, and Experian credit reports and all 3 scores. If you have debt collectors coming after you, grab my 3-pack of letters. It has this right here, this stuff that I just talked about has always been in my 3-pack of letters. It has a statute of limitations letter, debt validation letter, cease and desist collection activities letter. I do ask for a donation on those, but it could save you time, money, and frustration. And I really appreciate the people who are able to do that. Thank you for your time. Subscribe to the channel. Post your questions and comments. This is Stephen A. Williams, President and founder of thecreditrepairshop.com.